Good morning, and thanks for joining us here on Condo Solutions. Monday mornings, 9 to 10 o'clock. We're talking about condos and homeowners associations and some of the things that you might have questions about or want to know or need to know. If you're new to condos, or maybe you're, kind of a veteran and you've been here for a while, but you've got a different situation or an unusual situation, we're here to help you with that. My name is Mark Breckbill. I'm a CPA. I'm a licensed community association manager, and have been practicing in this area from an accounting and tax standpoint for some 25 years. And love the areas. I love what I do. It's fun. It's always kind of neat situation, and love to do it. Along with me today and always is Peter Mullengarden. Peter's our attorney, and he has been working in this area for hundreds of years, hundreds and hundreds of years. In fact, many people don't know, I've said this on the show before, that Peter originally received the first condo documents from Moses after he got down off the mountain. He handed out the 10 Commandments on the one side, and then he gave the condo docs to Peter on the other. So that's how long Peter's been doing this type of work. So anyway, no, but he knows his stuff. He's been here and been in the trenches for a while. So he's a great resource for us to ask questions of and to find out answers. And actually, if you got a situation, he's a great attorney to use because he's been through it all before. So that's the basics of the program. We've been doing it for a little over 20 years on the air here, making this information available. So a couple ground rules. First of all, I'll give the phone number so you can write it down and you'll have it for future reference. If you do have a question, it's 772 220 9788. Again, that's 772 220 WSTU. That's the phone number in the studio, and you can use that for all of the shows pretty much. Most of them allow call-ins and and that's the studio number, so you can give them a call and get you on the air in most of the shows. Here we'll do the same thing. You'll call in, Evan will pick it up and find out your name. We don't need your actual name. We just need a name to call you. And if you tell Evan, you got a question, and he'll get you on the air. We have a couple ground rules on that. One, like I said, we need something to call you rather than hey you. And we also don't need your association name, because a lot of times that confuses people. They hear an association, say, well, that's not mine, so it must not be my problem. And they may tune out, or maybe they're just driving in the car and they catch it on the radio. And so they think, oh, it's not my problem. And so they don't listen. Maybe they surf on. So for that reason, we don't need the association name. We will try to answer your question the best we can, but we're going to give you what we call a radio answer. What that means is that we make stuff up. No, it really doesn't mean that. It means that we try to give you the best answer we can, but we don't have your documents. So therefore, we have to make stuff up. So we will talk about the problem. We'll give you the best answer based on your understanding of your documents, based on some of the typical situations that occur, some of the court cases, laws, things like that. But without your documents, we can't give you an answer that you can go to court with. So and take legal action with. So if you are planning legal action, you need to call Peter and talk to him about your situation so he can look at your documents and give you some solid advice. Otherwise, if you're just looking for some additional input, we're here for that, and we're a good source of that. Because we don't have your documents, when we do answer a question, we may talk a little broader than your particular problem. Bear with us. That's for those who maybe have a similar but not exactly the same situation, and they're too shy to call. But we do appreciate the calls. And again, 220-9788, 220-WSTU is the number in the studio. So good morning, Peter. How are you?
I'm well. Good morning, Mark.
I'm good. I'm always amazed. For you, Halloween's kind of an easy holiday, isn't it? Because you're kind of always dressed up scary. That attorney outfit gets most people going anyway. So you don't ever have to put anything on, do you? Peter, you still there? Where are you?
I hear you. Yep.
No, you're the friendly attorney. I got to admit, you're the friendly attorney. You're not the litigation guys that are like animals. You're that friendly, helpful condo attorney.
The accountants put them to sleep, and then the lawyers scare them away. So.
Yeah, that works pretty good. Well, we don't think of it as we don't think of it as really putting him to sleep. It's more and it's more kind of a just a drug to kind of slow them down a little bit, so that so
Oh,
so
it's an oak.
so that by the time they get to you, they're pretty relaxed and maybe only halfway there.
Oh, is that it?
Yeah, that's it. So,
Tag team.
yeah. Did you have a good holiday? I always like Halloween because we tailgate for in Florida. You tailgate for everything. We tailgate for football. We tailgate for Halloween. We tailgate for just about anything out there, don't we?
Uh, yeah, I guess it's a eating and drinking environment. But I didn't do anything special for Halloween this year, actually. So
Didn't you?
we had some kids come by, not a ton. Um, but I didn't go to a Halloween party. I didn't dress up, so I was not too Halloweeny this year.
Yeah.
That's okay.
What Speaking of that, we're talking about dressing up and going trick or treating and all of those kind of things. Um, what kind of what kind of issues do condos and HOAs have? I mean, how strict can they get on those kind of things, particularly HOAs? How strict and it's only one night, so how do they stop it? By the time you take action, it's kind of like a moot point, right? I mean,
I mean, I don't know. I mean, honestly, I never had any Halloween
complaints?
issues. You know, what I have had in the past is more Christmas, Hanukkah issues with and other holidays with house decorations. Um, how long do they stay up? How uh, how sometimes people go. I guess you can say I don't know if they go overboard, but they really decorate and put up some bright things, some bright decorations that other owners get annoyed by, shining over into their houses or things.
Yeah, I used to get that. I used to get that complaint about my
Halloween has
dragon.
never been an issue, at least not for me. But more with these other holidays, where association documents say, you can't make any, changes or alterations to your house or put up, you can't have, lights without approval and blah, blah, blah. I have honestly told association that unless it's something that's, extreme, with spotlights or something that, temporary decorations, it's not something that I'm gonna quite frankly pursue.
So if Chevy Chase moves into your community,
Yeah,
and starts putting
and
up the
lights
lights,
up exactly. So right, so you can see the house from space.
yeah, that one.
If you can see the house from space, and it actually is a nuisance. I can't believe we're talking about this, but I think one time, several years ago, someone put a huge lit cross like in their yard, but it was like way up in the air and shown over, and that annoyed some people. So that was an issue. I think other times it was some people keep their stuff up longer than others people think that they should. So, but
Well, I tell you,
honestly, I don't think I've ever written anyone about Christmas decorations or Hanukkah decorations or other things.
yeah, I got rid of my dragon last year, so I don't have I have a fire breathing dragon that.
But that was like the year of the frog or something.
No, I don't know. It's just he was out in front of my house. He was he had the little smoke that comes out of the mouth, and yeah, it was a good time. But yeah, that's why I don't live in a homeowners association. Although the place where I go and I'll kind of hang out to trick or treat, they have it's kind of an unusual situation. They have the award for the best adult beverages, and so you travel from place to place. And
we're back on tailgating already.
That's right. That's what I'm saying. It was pretty interesting the way that all worked. But But yeah, it's the guy next to us. He has the best. He has the best. He's got a full bar. But but anyway, all right. We got our first caller this morning. Thanks, John, for saving us from further discussion about Halloween decorations. How are you this
That,
morning?
that's fine. I hope you guys had a good one. I didn't want to call in first. I wanted to make sure somebody else had the opportunity because we had spoken last week, and I had a follow-up question regarding a payroll that the a homeowners association would set up. You mentioned an operating agreement, and I've gone to the property management company and asked them if there's any operating agreement, and they looked at me like I had four eyes. So maybe I said it the wrong way.
No, are you talking about for the LLC that was set up to run the payroll?
Exactly.
Yeah, every LLC should have an operating agreement, just like a corporation has articles and bylaws, articles of incorporation and bylaws. An LLC has articles of organization and an operating agreement, and that
Okay.
and
I
that's
think I
what.
know what I did wrong. I asked the property management company if there was an agreement between them, but this just has to do with the LLC.
Yeah, it's how the LLC is set up. Both of those things are important, by the way, and just as a side note, we talked about using the LLCs, and I'm in favor of doing those if they're done correctly, but because they do provide some additional protection for the association. But one of the things that is good if you can. Uh, you should have an operating agreement. It should be a written operating agreement, and it doesn't have to be if the LLC is owned 100% by the association. It doesn't have to be very complicated because there's no buy sells, there's no death of the association, those kind of things. So, um, it's it's pretty straightforward. But there should be something. I also like to use certificates, just like stock certificates. I like to use membership certificates in my LLCs because it makes it clear who and when owns it, and there's some further documentation that it's a legal entity, and that it's not just a percentage type situation. And
So I'm sorry to cut you off, but would the property management company that we hired, would they have a record of this?
They should have
have one?
they should have a corporate book, just like you've got a corporate book for the association with minutes and articles and bylaws and all that kind of stuff and stock certificates. You'd have a corporate book. You should have a corporate book for the LLC. Some people don't. They just go online, and I'll say this here because I say it to my clients all the time. I'll have and typically it's CPAs, and I don't know why they do. They think just because all they worry about is tax, that's all anybody worries about. And so they just go online and they pay the fee, and they say, you got an LLC. I set up your LLC for you. Well, you didn't. You just licensed that LLC to operate in the state of Florida. The other stuff you do makes it an LLC. The things that you do in terms of bank accounts and operating agreements and all of the things that you have with a corporation, written consents or some documentation of what's happened to the company. All of those things are what make it a legitimate legal entity, not paying the fee every year. Just by paying the fee every year, you haven't guaranteed that you're an LLC. I can pretty much guarantee you that if all you do is pay the fee and then you ignore everything else, commingle funds and don't document anything you do and don't have any operating agreement or book, I pretty much can guarantee you that if you do have to go to court, that LLC isn't going to be an LLC that's going to stand up from an asset protection standpoint. So, you may avoid some sort of cost for operating under a fictitious name illegally, but that's about all. So it is important that you have all of those things. They're less onerous in an LLC than in a corporation because LLCs aren't as formal. So that is an advantage. You can get away without you don't have to have annual meetings, and you don't have to have a board meeting every month and those kind of things with an LLC because they are less formal. But you still have to follow the formality of the organization. The other thing I was going to say is, and it's really important, I think, is your articles of organization. A lot of times, all the articles are required to have is the name and the address and the name and address of the entity, the registered agent, the operating, uh, the just the basic operating, not an operating agreement, nothing like that, just the basic information about the organization and where it's at. But there's an opportunity in the articles to add additional information, which puts people, including creditors, on record that there are restrictions on this LLC. That you can't transfer the ownership freely, that they don't distribute on a regular basis, or that there's no requirement to distribute, and those kind of things. Having that in your articles provides you with some additional protection from creditors, because they're then on notice publicly, and they can't say, well, I didn't see the operating agreement, it's not public, I didn't know that this was manager managed, or that, whatever. Well, it says right here in the articles, and that's public record. So that's the other
So
thing.
they would have to file that with the clerk of the court.
It's filed with the state. It's filed with the Secretary of State. And
so if I wanted to look up an LLC, which website would I go to?
sunbiz.org, sunbiz.org, and then you can do a name search, and you put in the entity name, and it will bring it up.
So would the articles of incorporation, would I be able to access that through that?
The articles of organization, yes.
Organization.
Yeah, they'll be there because they have to be filed with the state. The operating agreement does not, so it won't be there.
And the operating agreement is comparable to what?
The operating agreement is actually comparable to bylaws, but it's expanded. So, like with a corporation and in a general corporate environment, you have typically with a corporation, you've got your bylaws. Then you may have shareholder agreements, buy-sell agreements, shareholder agreements. You may have other restrictions on activities or things like that.
Okay.
But with a LLC, all of those things are built into your operating agreement. So, an operating agreement for an LLC can be a little longer sometimes, because it covers things like what happens if a member dies. Can you transfer? What if you want to transfer a membership interest? What are the restrictions? Who has to vote? And when do they become a member? When don't they? There's that kind of information, and it's all built into that operating agreement. But that operating agreement is not public, and so that's one of the good things about it, is it's not a public document.
But that leads me back to that question. Since they did not want to go through the property management company to hire employees to do handyman work, they wanted to create this LLC. Does the management company get a copy? I mean, they're not entitled to one since it's not public, but should the management company, if a homeowners association has one, get a copy of this operating agreement with this LLC set up for the homeowners?
Well, if they're party to a contract with that LLC, they need to know, and they have a right to.
But what do you mean by party to the contract? All they're doing is taking money out of our main account for the POA to pay these employees. It's just a withdrawal.
Right.
So do you need an agreement to make such a withdrawal with the property management company who oversees our bank account?
Yeah, you would. I mean, the property manager has to have authorization to, so you would have some. I mean, the property management company would need to know what kind of restrictions there are and what kind of protections are in place, and who has the authority to make decisions when they transfer that money in. So, it's just like, for example, if an LLC is borrowing money, yeah, the operating agreement isn't public record, but the bank is going to want to see it, and they're going to want to know who has authority. And that's the big thing you're looking at, because the articles should say whether the organization is member managed or manager managed, and it should say who the manager is. But it's always it's good to see what is the authority of the manager. So in Florida, a manager can have all of the powers to control everything. In other words, in Florida, you can you can bestow those powers on the manager, and that manager has complete control under Florida law. If you don't restrict it, they have complete control to pretty much do whatever the owners could do. So you need to see what kind of authority. Do they have the ability to open a bank account? Do they have the ability to borrow money? Do they have those kind of things? Or just, and who is it that has that authority? So that's what would be
Yeah.
in there. That's the kind of stuff that would be in those documents. And
Yeah, I haven't seen the details, but I think what they did was they just did what most people do. They set up an LLC thinking that's all they got to do, and they're just simply sending an invoice to the management company to pay this LLC. And of course, the LLC is who pays the payroll, but none of those details are theirs. They're just sending a simple invoice saying, we need X amount of dollars, and it's coming out of our operating account. And unfortunately, people don't understand all the details that you're correctly describing. But I don't think that's the way it's going down.
Yeah, and you should have that.
Disturbing.
You should have, for example, there needs to be something, because the way that you've described it right now, and if you're right relative to how it was set up and things, basically that's doing nothing. That's just a waste. That's just a waste of money. If you're paying the association's employees out of this entity, but there's no contractual requirement to do so, there's no outline of why or what's happening there, then that isn't going to hold up. I mean, it's obviously not going to be a separate entity with a separate set of operations and experience and requirements, and so it's probably not going to hold up. An attorney could pierce that corporate veil pretty easy, because there's really no economic reason for it other than to avoid creditors, and you cannot set these things up solely just to avoid creditors. They have to have some sort of general purpose. And
so all those good reasons you mentioned about setting up an LLC for liability purposes, that would not hold up.
Right, it would not hold up. It probably would be shot down right away. And in my experience, the first question that an attorney asks is let me see your insurance policy, and then the second question they ask is let me see your corporate book.
So the LLC would have its own insurance policy through an insurance agency.
It needs to have, if it's legitimately paying its expenses, it should have workers' comp and all of the required payroll type items.
But in this case, with a homeowners association, it can't piggyback on the homeowners association's insurance, right?
It could on the associations. It could be an additional named insured for liability purposes.
Okay.
Things like that.
And
Usually
if that's the case, then they wouldn't have to go out and get their own insurance. You could piggyback.
Yeah, you like I said, you'd still probably want, you'd probably still want some sort of primary coverage, but it would just really be a transfer from what you used to have to the new entity. It shouldn't really cost significantly more. The funny thing is, it actually should cost less because it's providing the insurance companies with more protection, but they don't seem to look at it that way most of the time. But you just you're just adding that additional layer of protection, and there should be some sort of there should be just some sort of an agreement with the association. So the association is going to is going to is going to hire this LLC, is going to enter into this agreement with this LLC. The LLC is going to take over all the human resource activities, and in exchange for that, they'll be paid an amount or a fee to cover those expenses.
So the correct way should have been at a board meeting. The LLC comes with all the paperwork we discussed, the contractual agreement, the operating agreement, and present it to the board. This is that way we're going to set it up. And then a motion should be made to approve it. It shouldn't just be, we're going to set up an LLC and it's not even discussed at a board meeting as far as all the details go.
Normally, you probably wouldn't. I mean, you could delegate that authority to the president, I guess, who could then, meet with the attorney and and do what's necessary. But usually the attorney's going to want to know what you're trying to accomplish if it's being done with an attorney or somebody who understands this stuff. So
Yeah.
they're going to
Well,
want to want to
yeah. Well, in this case, the president just went up, and I don't know if she did call out the association attorney or not. I'm sure she did, probably because she's using him as her personal attorney. But none of this has ever saw the light of day as far as a board meeting goes. I mean, it's not out there the way we just described it. It's just something that was discussed at a board meeting. We can hire these employees, and as far as setting up an LLC, that was never mentioned at a board meeting.
Yeah, it's it sounds like there were some shortcuts, and that's that shouldn't happen. If you're going to do it, you should do it right.
Are your programs recorded where you can go back and listen to them again?
Not all of them, but on YouTube, yeah, we have stuff recorded on YouTube.
WSTU, you just go on YouTube and punch that in, and you can hear.
It's WSTUTV.com is what you
TV.com.
Yeah, WSTUTV.com.
I didn't know they had a TV station.
Well, it's it's interesting with radio now. They have multiple channels, and you can actually have streaming video. If you can actually set it up with streaming video. So we have that right now on the regular, but it is on WSTU TV. .com. They store those old shows for because
if I go online, I can see you sitting in the studio. I think usually years ago I did that once.
Yeah, when I'm not running to the restroom and back, but yeah, I'm usually right. I'm usually right here.
Now,
Evan's got me on now.
Can I segue and involve Peter in an issue here?
No, we're not involving Peter today because he decided not to ask him any questions. Yes,
here's the situation in a community what's not fully built out because of 2008 and the bust. So a plan unit development doesn't get built out. But years later, now here we are with another housing boom, and a developer, a big company, national company, wants to come in and buy lots and develop them. And they don't have to replat it. They want to build townhomes, and it's built for townhomes. But we do have in our PUD, it specifically mentions when the developer was still there, and then it mentions when the developer goes away, the homeowners association will be responsible for architectural review. The city attorney is telling me that, that's just in the PUD, that we don't enforce that, meaning at P&Z, when they do a compliance review, which reviews the PUD, they don't ask the developer, have you gotten written approval of your plans from the architectural review committee and that homeowners association? They won't ask that. There is no, I don't know if they have a long checklist of stuff, but that's not one of the questions they ask. And to me, if it's written and enumerated in the PUD, and it clearly mentions in another section of the PUD that before they can have building permits issued, that it has to be approved by the architectural review committee. Is this in a PUD, Peter? Do you see this language? Is this common language in most PUDs that you're aware of?
You mean common language that
as far as an architectural review committee goes?
Well, I would say yes. Now, different PUDs, different site plans, they do have different conditions for approval. But if these, so I can't really speak to what might be in the PUD. I would be more concerned, quite frankly, with these lots supposedly are subjected or to be subjected to, if they're not already, to your declaration, right? So your declaration has language in it regarding architectural approval. And unless this is a successor developer and there's an exemption in there, any construction typically is subject to approval of the ACC or the ARC or whatever name the committee has. So in addition to, whatever's in those, PUD guidelines or, site plan guidelines, requirements, I'd be curious to know, just in general, just through the HOA documents, notwithstanding what the PUD might say, again, unless this is like a successor developer and they have an assignment of developer rights and the developer is exempt from architectural review, that to me, that's also equally important here as to, what is in those documents regarding, these lots.
Yes. Well, in our documents, it clearly mentions that all buildings have to be approved, and we call it a different name, but I'll just stick with the Architectural Review Committee. So it's in our docs,
Okay.
it's in our bylaws, and that's not the question that we're running into here. What we're running into is, again, I hate to bring this wonderful person up, but our president led this national builder to believe that they did not have to go to the Architectural Review Committee. So that's when I called the city and I asked P&Z, because it's not, P&Z just has to do a quick review before it goes through all the other reviews. And it goes to different departments. It goes to the utilities and a couple other departments, and then they all come back, and then eventually goes to the building department. But what I was trying to do is head them off, because again, the president told them, oh no, you don't have to go through the Modification Review Committee. And that's what we call it. And I told the city that it's in the PUD. It specifically mentions in the PUD. And they said, well, that's just written there. That's not to be taken where the city will get involved. That's something that you and the builder have to work out. And what I was trying to get through to them is it has a language in there that says before any building permits can be issued, it has to be approved by the Architectural Review Committee. And I'm not, an expert on PUDs, but to me, that seems a very unique situation, since we are a community development district, which is a public entity. And since it's all enumerated in the PUD, I'm thinking, well, this is not your normal run-of-the-mill PUD where, most cities are not going to get involved with asking the question, did you get approval from the Architectural Review Committee? And I was just curious if you've
generally, you're right that in order to get a building permit, you have to go through the checklist of what are the PUD requirements. Okay. And that, someone from the governmental, whether it's city, county, whoever, needs to be checking off that list. And by the way, the president, whoever he or she is, that person does not have unilateral authority, quite frankly, to speak for the association, right? And no individual officer director does, unless, as Mark said before, there's been some sort of delegation of something. So that person can't just waive those rights.
And the board can't delegate certain responsibilities either. So
right. So this again, it's hard to speak to every aspect of this without reading the stuff.
Yeah, I didn't want to get into the board aspect of this, because I didn't want to get in, confuse the question. But I think you just answered it. If it should be on a checklist that says, hey, you do realize you're moving into a deed restricted community, and and they do have compliance issues here. So did you? And it does say it in the PUD. As far as architecture review, did you get an approved application from the homeowners association art committee? But the city keeps telling me, well, that's a private issue. We don't ask those questions. That's between you and the builder.
Yeah, and that probably is, that to some degree probably is, because once an association or a property is turned over, that responsibility becomes the association's responsibility to monitor and manage that activity. But
it sounds like your president has said, yeah, it's fine. It's okay.
Yeah.
So the city's like, well, your association agreed to it. So what are you talking about?
Yeah. Now, the one thing I would do is look at to see if, I've had these situations before where the project went bust, and it was maybe supposed to be a 2-phase project, and they only built the first phase or whatever, and then it turned over, and at that point, that developer doesn't have any rights different than, unless they negotiate, they don't really have any rights different than the rights that somebody coming in buying a house has rights. And so a lot of times, if a developer is actually going to develop a property that's already under an existing association, they're going to negotiate a contract for their units that is, it may dovetail with the association documents, but but a lot of times it may have different language. Um, particularly if it's going to be a different association, maybe within the master or something of that nature. And so you might see if contractually somebody signed off, that should have gone to the board. But it is possible that somebody negotiated a contract that is allowing them to bypass all of this. But short of some sort of rules that have been approved, and some of that, Peter would know better. But I think on some of those kind of things, even the board can't negotiate away. If you're giving up certain rights, the members would have to approve that. If they're giving up, architectural rights or whatever else, those things
Well,
are
probably
valuable.
would not end up being a member issue, but I mean, yeah. So I don't know what, but you're right. I mean, they come in just like any other owner, under these documents again, unless there's been some sort of deal or an assignment of developer rights or an assignment of declarant rights, and so they got some exemptions or something. I don't know.
There is a couple.
Yeah.
There's a couple
Yeah, I
of
don't-
different there's a couple different things that come into play. We haven't seen them in a while, but you got what they call bulk sale rules, and there's another one.
Well, that's for condos.
Yeah.
Condos are the bulk sale rule.
Yeah, and then what's the
Not
other one?
HOAs.
No, that's right. But what's the other one?
Hold on a second. Would it also mean, Peter, bulk sale of lots?
Well, the bulk sale provisions are in 718,
Yeah,
not in
so-
720.
Yeah.
Oh, okay.
Yeah.
Okay. I'm sorry.
Yeah. So I
So
was.
that-
This
so-
was
so
a
that
bulk.
one
This
come
was a
into play.
bulk
But
sale of
there's
lots
still-
from.
But there's still the general. Again, I'm making this kind of simple. I understand that, but there's still the general rule of you're coming in, you're subject to these covenants,
Right.
and under these covenants, any kind of construction must be approved by, in your case, the modification committee or modification review board or whatever it's called. And plus there's the PUD stuff. So unless there's something, exempting or deal or whatever, I'm just not sure how. Usually the only exemption from that is, Mr. Developer or Miss Developer, has certain exemptions and can do what they want outside of the normal approval process. So I know I've been repeating myself.
Yeah, I'm not aware of any
that's
agreement
the
like
sticking
that
point
unless
that
it's done behind
How are
closed
they
doors.
getting around? Now, saying what the PUD says, how are they getting around those documents to build something else?
Yeah.
Because the president at a board meeting had the builder, and I know we get kind of confused with the terminology, and you can correct me, but to me, a builder is coming in and just building on lots that are already platted. A developer comes in, they have to plat, they have to maybe change the zoning from commercial to residential. Am I wrong there as far as a developer compared to a builder?
Those are different. A builder, yeah, I mean, one has declarant or developer rights, and the other doesn't.
Yeah.
Builders.
So this is not a developer. This is a builder that came in and picked up the other builder. They didn't go out of business. They had a product. They couldn't sell it. So then the other builder came in, the national company.
They don't have to
and they want
subdivide because they're buying subdivided lots. They're already divided. They're all ready to go.
Yep.
But John, is your association turned over? Is it still under? Is that association
No,
still?
no. That happened years ago. That turnover happened like 15 years ago, and we are a POA actually because we have commercial tracks. So we're a POA and a CDD. So we're a very strange animal. And go ahead.
No, are these lots subjected to your declaration, or is there a supplemental declaration that's bringing them in that can change the restrictions regarding them? I don't know.
No, yes, there are supplementals for the neighborhood, and there's nothing in there that changes anything about not going in front of a modification committee.
Okay.
Well,
so the builder comes in, and all they got to do is, it's already subdivided. And they're going to have the same footprint. But the problem we're running into is the community that lives there, the people that live in this community that's not totally complete, is going to have a completely different looking building than what the national builder wants to build in there. And this is what the RUHA is all about, because the builder came in front of the board and stated that this is a concept that we want to build. And they never presented specs. They never presented anything as far as, the details go, what you would normally present to the modification committee. So they came back again, and it's the same thing 2 times. And the second time, he didn't change anything. He said it's still a concept. And I told the board each time, I said, you do not have the authority to approve anything. You can give your blessing, but that means nothing because it's got to go through the Architectural Review Committee. That's what it says in our docs. Nothing can be built unless you have an approved application from the Architectural Review Committee. But the president led them to believe that they did not need this. Well, our attorney has since ruled that no, you do need to go through the Architectural Review Committee. But it is my opinion that since you led them to believe that you had the authority, it would be unwise to change it now.
Oh, by through some kind of a apparent authority that they relied upon?
I don't know where the attorney pulled it out of his hat, but apparently, yes, what you just said, because they relied.
Because sometimes, I mean, there is this thing called apparent authority, and if someone has the apparent authority, that could be binding on the association. So I think sounds like the attorney is saying, well, because they relied on this apparent authority, that you guys may be stopped or have a waiver issue or something like that. That they relied on this. He had the apparent authority, and therefore, it's not worth, or you're not in a strong position, perhaps to go back. Sounds like.
Well, here's my argument to that. They're a national company. They got a bank of lawyers. They pull all the docs from the clerk. They don't have to pay for our docs before they even buy. They pull from any clerk of the court website, and they know that we're a deed restricted community, and they know because they sent us an email, and the very first email they sent us was, we want to get in front of your Architectural Review Committee. We understand it's on such and such date. This was back in April of this year.
All right, good point, because the flip side of the apparent authority argument is they're a sophisticated party. They know better. They should have known that Mr. So-and-so didn't have this authority, and therefore it was not reasonable to rely upon it.
Exactly. So this is why I got the city involved, because to me, instead of going through lawsuits and stuff, why not just get the city to do their job and have it on a checklist?
But
check it off.
That's the problem, though.
It sounds like the city is backing off, saying that this is between you and this builder.
And it is really, because the authority here is your Architectural Review Committee, which is an association committee. So the city doesn't really have any say in that, because that's not the city's responsibility. And I think they are right there. What's going to govern is your homeowners association documents, which those are going to.
Let me just interject here. Let me just read this real quickly to you, because this is what the PUD says. It says, during the initial development period, enforcement of architectural guidelines and standards related to institutional, commercial, and multifamily residential buildings will be verified at the time of site plan approval. A condition of the city's site plan approval, while required the developer's written approval, that the respective buildings conform to the architectural standards and guidelines which follow. Thereafter, here's the key part, thereafter any changes, additions, or deletions to the buildings by the property owners will require written approval of the Architectural Review Board of the Property Owners Association of the PUD prior to obtaining permits from the city.
Yeah, see, so that's very clear, and
that's changing the existing.
But it says right at the beginning, John. It says the developer, right? You don't have the developer,
but then it says thereafter.
Right, thereafter, it's the individual unit owner. So you don't have a developer here. You have it. That's what I was saying before. A developer has declarant rights. They are a specific beast. Okay, they go away once the association is turned over. A builder coming in, a national builder, whoever, is not a developer. They're a builder, right? And they are buying units, lots, and they are subject to it just like any owner would be, because there's no longer a
property owners. I got that.
Right. So
that's what I just read.
Right. So what I'm saying is the city is absolutely right. While it's under declarant control, it was signed off when the site plan is submitted. But once it's no longer under declarant control, it's under a builder or an owner or somebody buying a lot or building a house or whatever, that then goes to the architectural review committee. So because that language is old language, we talk all the time about getting stuff out of the documents. That's old language that had to do with when it was under developer control. And under developer control, the declarant didn't have to go through an architectural review committee. They could just have it signed off by the city under whatever rules they were following. But once it turned over, there is no longer a declarant. So therefore, everybody is an owner. And so now everything goes through ARC is the way it works.
Okay.
See?
But how do you read that last sentence? Doesn't that say that before you can build, the city's not going to give you a permit until you've been approved?
Well, that sounds like it said. I think it said like the existing homes, any change to get permits for changes to those existing homes, you had to get approval from the committee.
Right.
But I would think to get a permit, you would also have to show approval for the new homes by this new builder.
Yeah.
And I think that's where the rub comes. They're thinking that your association has approved. Sounds like.
Yeah. Well, they don't know the inside story, the politics of what I have explained to you. But to me, I don't understand it. Let's forget about everything we talked about. Deed restricted community. Let's talk about that. I would just think that the city would respect a deed restricted community and know in their bylaws that they probably have certain restrictions as far as buildings go. And that's always the key word, building. What are we talking about? Because here it says thereafter any changes.
Yeah, but
it says additions or deletions.
But I think your city is relying on what your association is telling them, that it's been approved.
Yeah.
Okay. Thanks, guys.
All right. Thanks, John. Appreciate the call. That's one of the things we probably could talk about architectural review committees a little bit too, in terms of the authority they have and what kind of rules they have to follow. Maybe we can do that next week. We appreciate you joining us this week and having questions and calling in. Write the number down, save it. Join us every Monday. We're here from 9 to 10 o'clock. We're here for you, so we're going to answer your questions the best we can. And we're constantly doing that. We've been here for over 20 years, right here on WSTU, Digital 1450. We are Martin County's Heritage Station.